So I said that they need to prove to the specified standard based on the policy delineated bases for appeal. So your policy needs to outline what those are. You can't just say appeal, because to everyone else that means if I disagree, then I can appeal. And that's not what an appeal is. Everyone, if they're angry, there's always someone who disagrees with the finding. That's why they want to appeal. That's not what this process is. Disagreement doesn't meet any kind of standard. So it's not a valid basis. So you need to make that clear. So here are some examples. You may just use these. You may include others. You may word them differently, but they're essentially the same thing. The first, the investigator did not follow the policy, or there was a procedural error in the process. This is why it's so important to consistently follow the policy, because this is a valid basis for appeal. They didn't give me the policy says I can have 15 days to submit my statement or submit evidence, and he closed the case after 5. So I didn't get a chance. The policy says I'm allowed to present witnesses, but the investigator never asked me for witnesses. So that's a grounds for appeal, that the policy or the process was not followed as outlined. Another one is new evidence. And new evidence is also a basis for appeal in the criminal justice system. Think of all of the cases of people who were convicted and have been in jail for 20 years, and then after DNA came out, they were exonerated based on DNA. The blood evidence was already there, and back in the day, they may have used blood typing or some other sort of test to convict this person. So the actual blood isn't new evidence, but the method of analyzing it, so the DNA analysis, is new. And so that analysis is new evidence. So that is a very valid grounds for appeal, that some sort of new evidence came to light after the finding that changes things. And another one is a misstatement of a material fact. So this is important because the fact has to be material to the outcome or to the case. So it has to actually be something important and relevant, and then you have to be able to show that the investigator misstated it or got it wrong. And it doesn't have to be on purpose. It could be an accident. But those are 3 pretty general bases for appeal. They pretty much cover every valid reason you would want to appeal. But the important thing that the reviewer is looking at is, did one of these factors impact the outcome? So that's kind of the second step, is, did one of these factors exist? And if so, did it impact the outcome? So going back to, he didn't give me 15 days to submit evidence. Well, if the investigator documented that he asked if there was any evidence and the respondent said, no, I've got nothing, I don't have anything to provide, and the investigator said, okay, well, you have a certain amount of time, and the person said, no, go ahead, I'm not going to give you anything, so just, and then the investigator said, well, I'm still going to wait a few days to let you think about it. If the respondent didn't have any evidence to submit anyway, and still doesn't, then that didn't, proceeding after 5 days instead of waiting for 10 didn't impact the outcome. The outcome would be the same. No evidence after 5 is the same as no evidence after 10. So there does have to be an impact. Explain in your policy what each basis means, and then what is required to meet that standard. So explain, procedural error means that the investigator did not follow an aspect of the policy or the process, and that action negatively impacted or had an impact on the finding. You may want to consider not giving examples. So whenever you give an explanation, it's very easy to follow it up with an example. I worked with one organization where they, under the procedural error, they listed bias as an example to try to help people understand. Well, guess what? Every single case they got was appealed under bias, because that was a way to fit disagreement with the outcome into one of these factors. So by giving them the example of bias, they essentially guaranteed that they were going to get an appeal on every case, and it was always going to be bias. Because we said in our policy that was a great thing. A great one to appeal is bias, so everyone did it. So be careful when you give examples, because you may lead to this situation where everyone is using your example, even if they don't really understand what it means or they don't argue it properly. You're still getting appeals based on that just because you put it down. They didn't have to think of something else because it was right there in front of them. So just a thought on when you're defining what that means. If your investigation standard is the preponderance of evidence, which most administrative cases are, and they are rightly so, I believe, because that is also the same standard that the civil courts use in a civil case, and an administrative case is civil. If someone disagrees to the point where they want to sue you, they sue you in civil court. So the judge is going to look at it using that standard. So it makes sense for you to use that standard as well. But if that's your investigation standard, your appeal standard probably needs to be a little bit higher than that. Remember, preponderance is more likely than not, or just over 50%. So you can have two reasonable people who disagree on a preponderance finding. You can have one person that falls at 51% and someone else who is equally as knowledgeable and experienced fall at 49%. So if you have your investigator fell at 51 and then it goes to appeals and that falls at 49, now you're arguing the finding. You're not presuming the finding was correct. So you probably don't want it to be beyond a reasonable doubt, like the courts, but you could jump up your appeal standard to clear and convincing, which is between preponderance and beyond a reasonable doubt. So that will help you continue or maintain that presumption that your finding is correct. Talk to your legal department, your general counsel, on how they would prefer that you handle that, what standard they would prefer that you use. But it makes sense to have a higher standard for your appeal. Articulate that in your policy so that they understand what does clear and convincing mean, so that they know when they write their appeal that they are writing it, they're arguing to that standard. So they need to provide the arguments and the evidence that meets the clear and convincing standard in their appeal. Because during the investigation, they were providing evidence that they felt met the preponderance standard. And I keep saying, include this in your policy and your process, give them a document. This needs to be a transparent process. This shouldn't be a mystery. Remember, they don't know how this works. They don't do this every day. So not only is this something new to them, but it's a very emotional and an extreme situation to them. This is your normal course of business. This is what you do every day. To them, this is a very extreme thing that is going to have a major impact on their life, on their family, on their career. So you need to make it very clear and simple to follow. Now, your reviewer, and the reason why I mentioned earlier that it's important to only have one, maybe two reviewers, depending on your caseload, because the reviewer needs to be trained in their job as a reviewer, exactly what they're supposed to do, and they need to know the policy and the process. They need to know when they read an appeal and someone is arguing that you didn't follow your policy or process, the reviewer should know right away what the policy says. And yes, they want to refer back to it to make sure they get it right, but they should know it well enough that they can look at an argument and say, that's not in the policy. That's not what the process says. That's not what it means. I've talked to the investigator. I've been trained on how the investigation works. That's not what happens. They should know what the steps the investigator took to get to the finding because they are familiar with the process. So they may feel like they need to be completely separate because they are this objective third party reviewer, and so we need to not have any kind of connection with the investigator at all. That's not really true. That's like saying a judge who is hearing appeals should never have actually sat in on cases, and that's usually part of their career path. It's okay for them to talk with the investigator, to get training, to talk through issues. It's even okay for them to ask questions. They just can't be involved in the investigation if they're going to review it. So they shouldn't have any specific knowledge of the investigation prior to getting the appeal, but they should know everything there is to know about the process. And they need to invest the time, and you need to invest the money in getting them trained as well, even though they're not doing it every day or as much as the investigator. It's just as important that they get it right as it is for your investigator to get it right. The reason why this is important is because when they're not trained, when they don't know their responsibilities, it makes the process actually longer and more difficult for them. They're going to receive this appeal that's arguing all of these different things, and most of those may not actually pertain, or they may not be under one of the allowed grounds or basis for appeal. And so they're going to go on this goose chase and go down these rabbit holes of arguments unless they know exactly what their job is. So that review needs to be, there's actually kind of an initial assessment phase. Does the submitted appeal meet one of the bases outlined in the policy? That's the very first question you ask. Based on the examples I gave, there are 3 allowed bases. Does this appeal actually meet one of those? If no, the appeal is rejected. I'm not even going to hear it because you're not arguing one of the acceptable bases. If yes, then they look at it, does the appeal meet the required standard to overturn the finding? That's when they actually have to dive into the appeal. It's not the reviewer's job to search for evidence. It's not the reviewer's job to reinvestigate. It's not the reviewer's job to have to go through and read every single document to try to support the argument that the appealing party is making. All of that should be contained in the request for appeal. The reviewer's job is to review that request and see if that request meets the standard and is based on truth. So if the appealing party says, in his interview with me, the investigator failed to do A, B, and C, then the reviewer can look at the documentation of that interview and search for A, B, and C. The reviewer is not a defense attorney for the appealing party. They're not an advocate for the appealing party. They're not an advocate, or they're not there to help them prove it. I have worked with organizations where they were having issues with reviews, and I found that the reviewer saw herself as an advocate or defense attorney and said, well, this person's not a lawyer. They don't know what to look for, what to write, so I'm going to help them do that. So therefore, I essentially took their basic argument and then I built the argument out from that. That's not your job as a reviewer. In fact, that's should be way outside the lines of the responsibilities in the policy. The reviewer has very specific parameters and is limited to those parameters. And that's a good thing because that makes their job easier. They're not spending their entire day they doing reviews. Generally, your reviewer is going to be someone with additional responsibilities because there's not enough to be full time. You don't want this to take the place of all of their other duties. If the reviewer's looking through this appeal and there are arguments in there that aren't relevant, that aren't included in one of the bases, that are essentially re-arguing the original case, they shouldn't even analyze those. They should articulate, this is just, you're re-arguing the original case, this has already been decided, already discussed, not relevant. And they should be able to kind of line item veto, if you will, those lines or those paragraphs and only look at the arguments that are valid, relevant, and based on an actual allowed basis for appeal.